his words.
Welcome, everyone, to our afternoon session at the Appalachian Justice Symposium. It's my pleasure to introduce the next panel, Views on the Administration of Criminal Justice in Appalachia from the Bench and the Bar. This panel will debate the unique features of a criminal law practice in Appalachia. It will assess the factors that impact the administration of justice in the eyes of the court, the prosecutor, and the criminal defense practitioner. I'm going to hand it over to my dad, Jeff Smith, the moderator of this panel, to get started.
Which of course makes it the chief qualification to be here. But, thank you very much for this invitation. It's truly an honor to be with you. I was here all day yesterday and went to a number of the sessions and have been very impressed and very thankful for the opportunity to be here. Yesterday's comments by a number of the panelists, and somewhat today as well, have approached this scourge, if you will, on our communities, sometimes from an academic or a theoretical point of view, which is a necessary thing and a good thing. Our point of view is going to be really echoing what Judge Alloy just commented to us about. What do we do with the person who's right in front of us? What do we do now? And so from criminal practice practitioners, you're going to hear our point of view on what we do and what we think we maybe need to be doing. You're going to hear from two very seasoned, experienced judges, too, about how they address these issues. So our presentation is real world, practical, not perfect, imperfect, but what do we do with the person that's in front of us? Many of the aspects of administration of justice in Appalachia, there are many things to talk about. There's no way we have a chance to adequately address any of them. We're as you might predict, going to be heavily weighted toward the opiate problem, but we'll try to address other things along the way as well. Judge Russell Clawges is a 20-year veteran of the circuit bench here in Morgantown. Practiced law prior to that time. He is a recognized figure here to you, I'm sure, having taught at the university. He's active in continuing education for lawyers and judges. And Russell Clawges, Your Honor.
Thank you. It is an honor and a pleasure to be here this afternoon. I've got a lot of respect for the College of Law, not just because I'm a graduate of the College of Law, but for the work that's being done here through Dean Bowman and certainly the work that I've seen through the law review over the last few years. I'm sure most of you, if not all of you, heard Judge Alloy's presentation at lunch, and there's really not a whole lot that I can add to what he said, and in fact, most of what he said I would have said, and I echo. Couldn't have been said better, and it couldn't have been said more accurately. You learn a few things when you've been around a while. One, I guess, with age comes experience, and sometimes, whether or not it's warranted or not, the belief that you have some wisdom or knowledge that's beyond what others might have. I don't know how true that is. I have managed to stick around for a while. I have learned a few things. I've learned that most of the people who go to prison get out. And in fact, the vast majority of the people who go to prison get out. And I've learned that for the most part, the people who go to prison are pretty much the same person when they get out, unfortunately. And I can tell you that that's a fact for those who go to prison with addiction. You can keep somebody in prison 1 year, 2 years, 5 years, and if they were an addict when they went in, and if you've been able to keep them away from it for the 1, 2, 5 years that they're in, within a week to 2 weeks to a month, they will have found a way to use again. Despite the best efforts of the prison system, despite the RSAT program, which is actually an evidence-based drug treatment program. Although interestingly enough, statistics show that people who are on the outside and go through that program have a substantially greater success rate than those who are on the inside and go through that program. And I think that compounds Judge Alloy's remarks from the standpoint of we need to deal with this problem, not just on the backside because it's not adequate. I can tell you the frustrations that I have developed over the years as a judge on the front end of things, and that is the lack of resources that we have as judges. To echo in a comment that Judge Alloy made, and that is the question that is asked of judges is, why are you getting involved in this? And my job has evolved. I mean, I'm not a social worker, I'm a math major. But I've become a social worker because these problems, for some reason, and I'm sure Judge Keller will echo this to a great degree, have been left to the judiciary. And in fact, I was asked a couple of years ago by a fairly prominent legislator who will go unnamed for a couple of reasons, why judges were getting involved in issues like truancy and why we were getting involved in drug courts and why we were doing this. That's not your job. And basically, and I'm remembered by some of my fellow judges, my response was, if the people in the executive and if the people in the legislative branches of the government were doing what they were charged with doing, we wouldn't have to do it. And we wouldn't be doing it. And seeing some change in that regard, but not enough change, because we still have the same lack of adequate resources when it comes to dealing with those people who are standing in front of you who have problems with addiction. When I started this job, there was a wise person who spoke to us and said, when you're sentencing somebody, you put people in prison because they scare you, because you're afraid of them, because you know that if you leave them out, they're going to do something to somebody else. You don't put people in prison because you're mad at them, and because they've got a problem that you just aren't able to deal with. That's great philosophically, and in fact, I spend a good bit of my time trying to figure out, okay, are you a criminal because of your addiction? Or are you just somebody who has chosen a life of crime and you'd use drugs on the side? And in fact, a lot of what I do is trying to figure out the answer to that question and dealing appropriately with those people. I'm hopeful that in the days and the weeks and the years to come, we're going to see much more in the way of resources for dealing with addiction. Addiction is not just a criminal justice problem. It's now a family court problem, which Judge senior moment, forgive me. And it's also becoming a problem from my standpoint from abuse neglect. It's funny, abuse neglect cases used to deal with parents who actually physically abused their children. Now most of the cases involve neglect because the parents are using drugs. And unfortunately, if we didn't have enough resources for the people that commit crimes, you'd think we'd have more resources for the folks that are involved in the abuse neglect system. That's not the case. I think that's all I have to say for now.
Thank you, Judge. Patricia Keller is a family court judge in the 6th Family Court District. That's Cabell County. Judge Keller was instrumental in establishing and creating and establishing and nurturing and developing the drug court in Cabell County. Courts, thank you, Judge. She'll be able to explain this to you way better than I am. She's a longtime member of the bench in Cabell County. You may recognize her from the Netflix short documentary film Heroin. And she's an adjunct professor here at WVU and has taught classes in the Master of Legal Studies program since 1999. Judge Keller?
Thank you, Jeff. I have to start off with a little bit of a disclaimer. I'm really kind of an accidental member of criminal justice in Appalachia. As Jeff said, I'm a family law judge. I started my career as a social work student. Always wanted to be a civil legal aid lawyer, and I had the opportunity to do that. Always wanted to practice family law, and that's all I ever practiced, both at legal aid and in private practice until I became a family court judge. I never dreamed that I would be at all involved in the criminal justice system. And, but it happened. And it happened because I was approached about starting a juvenile drug court in Cabell County. Once upon a time, we had toyed with the juvenile drug court and had been gone for a while. And they had the opportunity to reestablish one. But we didn't have a judge at the time who was interested in doing it, and the court was willing to give us money. Well, we've learned not to turn that down. So I'm like, okay, I can try that. You know, juveniles, I always thought that juvenile law ought to go in our family court jurisdiction anyway. So we started there in 2007. And then come 2008, the people in probation came back and said, you know, there's a chance to have an adult drug court. You want to do that too? I'm like, what do I know about doing criminal law? And they said, well, we don't have a judge that wants to do it right now, and there's money that we can hire a probation officer and we can do this. So, okay, let's do this. I was a little leery, I'll be honest, because I wasn't sure what my population was going to be. I will tell you, since I've been doing this in 2009, that I have absolutely loved the population that I've dealt with in my drug court, because you get to know them as people, which is something a judge never really gets to do. It's such a unique role for a judge, because normally you would expect us to be neutral, unbiased. I don't know about your case before you sit down in front of me, and that's when I learn both sides of the story and make a decision. But instead, you know, we have that treatment team concept where we meet with a group of people every week and we staff cases of people going through drug court, and we learn what's going on in their lives day to day and what motivates them, what will encourage them, so that we can apply those same things with them in court. Probably a day didn't go by that I wouldn't get a text from somebody on my treatment team telling me that somebody had a baby, or somebody relapsed, or somebody's at the hospital, or you just know things and you get to know these people. And I think that has been truly an eye-opening experience for me, is getting to know people and getting to see both prosecutors and defense attorneys working in that non-adversarial mode as well, because we're all working together as a team. So I have to say I like that very much. I think the beauty of treatment courts, and we have different kinds of treatment courts that are available, whether they're drug courts, mental health courts, they're domestic violence courts. There are different types of treatment courts around the country. Pretty much what we have in West Virginia right now is we have adult drug courts, we have a couple mental health courts, and we have probably a dozen juvenile drug courts that cover a portion of the state. They do make a concept called a family drug court, which is geared for people going through abuse and neglect proceedings because of drug addiction issues. Unfortunately, we don't have any of those in place right now in West Virginia. As Judge Clawges just mentioned, that is a huge, huge factor of people coming into the abuse and neglect court system. It's interesting how we can use the justice system and use these courts in other ways. We have a problem in Huntington, and I don't know if it's similar in other communities as well, but in Huntington we have a huge prostitution issue. And we had the police chief at the time come to us and say, hey, if you guys could put some of these prostitutes in your drug court, that would help our prostitution issue, because they're really all drug addicted. And we told him we'd love to, but you know, we just don't have enough room. You know, it's a very intensive supervision program that takes at a minimum a year, usually much longer than that. We didn't have slots, we didn't have space. And the court wasn't willing to expand our program because there are only so many dollars in West Virginia, and not everybody even had a drug court. So I can't give you a bigger one. And a couple years later, a new police chief for Huntington came back to see us and floated that idea again. And we said, you know, we want to, we just don't have the resources. And the city said, well, we'll help you. And they wrote a grant so we could get federal funding to start what we called our WARE program. And WARE was a specialized track within the drug court for women. We called it Women's Empowerment and Addiction Recovery, but it was for women who were engaged in the sex trade, that were drug addicted, and that was fueling their work on the streets. They needed something more than just a traditional drug court. They needed all of that, all of the intense supervision, the monitoring, the groups, the counseling, all the things that go with a traditional drug court. But they had such horrendous backstories that they needed some specialized counseling programs, even above what we did as far as treatment. And so we had to get to those underlying issues, those things that caused them to, you know, where they were sexually abused when they were 4 or 5. All these backstories that got them on the streets. And so we were able to add that extra track and that extra program. So you can find creative ways to deal with criminal justice. Because what we really want to do with drug courts is we want to reduce recidivism. We don't want people to continue to commit crimes. We want to reduce substance abuse, and we want to make them successful. We want the likelihood of their successful recovery. And it's such a long-term process. One of the things that Mike mentioned in his address at lunch that I really appreciated, and I hope that whatever branch of the law you all are involved in and will become involved in, that you'll kind of plant this seed in the back of your mind, and that's the second chances. Because we have 2 huge obstacles for our folks when it comes to second chances. And the one he mentioned are the felonies. And I think about that because he told you about the 2 voices on his shoulder. Somebody wants to be safe and somebody, you know, wants that opportunity and help. And in drug court, we have our chief public defender and we have our chief prosecutor. And that prosecutor is responsible for the community to making sure that they're safe and that we are punishing people. And so we're trying to convince him at times that, you know, we don't need this felony on somebody's head, because the problem is they're not going to be able to go out and get a job where they can really support themselves. That's always going to be hanging over there. So if we can look at those second chance legislation so that they have an opportunity that when they have been successful over a period of time, that can go away, that would be phenomenal in finding employment. But the other really basic thing you don't think about is getting around. You know, how many people going to drug court have a driver's license? Not very many. And that's not because everybody there has a DUI. They may have some other type of violation. And how do we raise money in West Virginia? When you get tickets, you know, we add on, there's a $5 fee for this, there's a $15 fee for this, there's another fee for this. And before long, there's a lot of money owed on even the most basic tickets. And so people can't afford to pay those tickets, so they don't pay those tickets. They get caught driving because they've lost their license because they didn't pay the tickets. So they get other tickets and more fees, and soon they owe a few $1,000s. And it makes it really hard to get their license back. One of the first girls, actually the first girl that came into our WARE program, she called this week to say, I did it. I paid off all $1,800 in fines I had. She had a minimum wage job, fast food, because remember, she has a felony on her record, lots of felonies. I paid it off. I can get my driver's license now. And we're lucky in Huntington. I mean, we have a bus service. That doesn't run on Sundays, and you got to sometimes take an hour to get somewhere that would take you, 15 minutes because they have connections. But we even have a bus service. So that second chance legislation, and there's so many things we can do to make this better. And I hope that if you ever have a chance, you'll do that. And I do want to just say that drug courts really do work. We kind of, our participants joke, I didn't realize this, and I went back and checked the statistics, and they were right. It's a 50% club. And what that means is the people that come into our drug court, about 52% that start graduate. So your odds of being successful are 1 and 2. And you have to understand, a lot of people that come into drug court, prison, I think I'll go for drug court. You know, sometimes they're just not ready, or there are other obstacles to them succeeding. But half our folks do graduate. And of those that graduate, after 2 years, the statistics show that only 8% recidivize. Whereas those that just go to prison for their drug offense, 80%. So it's a huge success story in terms of not going back to prison. And it saves money. The beauty of this is drug court right now costs us a little over $6,000 a year for a participant. It's going to cost us a little over $20,000 a year for us to put them in the regional jail, or $26,000 a year to put them in prison. So we're saving huge money. We're reuniting families. We're being successful. It's a win-win. So if you ever have a chance to get involved in a drug court, visit a drug court, do it.
Thank you, Judge.
Mm-hmm.
Cindy Stanton is the Chief Public Defender of the 28th Judicial Circuit. She's been doing that job for 30 years.
Mm-hmm.
She knows a lot about criminal practice, criminal defense practice. I know you're anxious to also talk about the abuse neglect petitions as well, but Cindy Stanton.
Hello, I'm glad to be here today also. Not normally the face man for the public defender system. I'm a little more radical than that. If you look at my picture in there, it was a selfie, the first selfie I ever took. And then I spent an hour trying to figure out how to make it black and white because I thought that's what you did, and so everybody else's is color and mine's black and white. So I come from I'm from Parkersburg, which is very, much larger than where I practice in Summersville. And when I first, actually I was a prosecutor for a little while, decided that just really wasn't my mindset. And so I got the job in Summersville back in 1987, and there were only 5 public defenders in the entire state. And the only reason that Summersville, and you think, why in the world would Summersville have a public defender? But Dan Callahan was the state bar president at the time, so he got to pick where to have one, and he didn't like doing criminal work. So that's why they had one there, and so I've been, like he said, I've been doing this for 30 years. I'm the longest serving public defender in the state. And I really come from a very, very rural area. There are only like 6,000 people where I live, and it's down where the whitewater rafting is. So it's kind of got a little more diverse population than most of the rest of the state because you've got some seasonal people coming in. I promised my local bar members, which there's 15 of us, that I wouldn't cuss, so I'll try very hard not to. And I told them that I wouldn't say that I think that the solution to the opioid crisis is legalization of marijuana, but I promised I would say that. So anyway, be that what it may, we were one of the last last circuits in the state to get a drug court. And I'll have to admit, and I told Judge Kelly earlier, I said I was not a fan. I didn't think it would work. Our circuit judge at the time was one of the last 2 that was kicking and screaming about having a drug court in, and since it was a single judge circuit, I kind of adopted the same mindset, I guess, because over the years you would see the same person getting in trouble time and time again, and nothing seemed to help, and we all thought basically that drug court wouldn't work. Then when the circumstances presented itself, we got a senior status judge, and it was Judge Rowe, who used to practice in Greenbrier County, along with Judge Kelly, was one of the pioneers of the drug court program. And I will say he has certainly made a believer out of me because it has worked. And I mean, I have clients that I had 28 years ago. There's one client that I did have 28 years ago that is now in phase 3 of the program. And I mean, none of us, we kind of had, and I hate to say this, we kind of have side bets on how long someone will make it. And
you do too.
And honestly, I was betting against him. But I mean, it truly has, and more than anything else, turned around so many lives. We're not nearly to the point, Judge Kelly had said they have 60 people in their drug court program at this time. We only have like 14, and we've only been really up and running basically just a little over a year. And as they progress during the phases, I mean, they have to do a lot of stuff that they've never done before, like get a job. And literally, we've sent people out to the community, to the community park to do community service, which is partly to keep their minds off the drugs. And they go out there, and then we get a call from the head of the park saying, they don't know how to run a weed eater. I'm like, well, don't be surprised they've never lifted one in their life, so why would they? But it's been a very, very positive experience, and we still have a problem with a little bit with the community. They still kind of call it druggy daycare, and I'm sure you all heard that.
Hug a thug.
Yeah, hug a thug. I mean, there are, it's a learning process for everyone. I try to, our biggest problem, and I think one of the biggest problems throughout the state, in particular in the rural areas where I'm from, is to find safe and suitable housing for these people in their initial stages. Because in the first stage of a drug court program, you can't work because you have to get yourself clean and get yourself in a right mindset. So that's very difficult if you can't go home to your parents who you've stolen off for the last 20 years, and there's not really a place to stay. That's one of our biggest failures that we're having with the people, is because there are not suitable housing. So I decided, well, some of us decided, we'd go to our local park has a series of cabins that rent out on a regular basis, and I went out there to see if we could rent one to get people in on a short-term basis. And naively, I'm just such a big advocate of the program, I thought the board members of the park would be, but they talked about the needles and everything else. So I think that we have a long way to go, but I think the way that we address the drug problem in our rural communities best is by finding the resources, because as everybody said, and you've heard it, you'll hear it probably from everybody today, it's resources are the problem. As Judge Clawges said, a big part of our practice, and there's only two of us in our office, there's only 2 lawyers. I was the only public defender there for the first 10 years, but fortunately now I get to hand off the abuse and neglect petitions to my associate who's under me. And we have had, since the beginning of this year, already we had 125 children taken last year, which for a county our size is just insane. And we're already up to 28, and then a few more yesterday, just in this year alone. So, and it's mostly like Judge Clawges said, 95% of our abuse and neglect petitions are people that are abuse their children, not in a physical sense, but it's more of a neglect issue because they're so badly into drugs they can't even perform the everyday functions of feeding, clothing kids, getting the kids to school on time, which leads to the truancy and the other problems. So the fact that we don't have a sober house in our community, we normally have to end up sending these mothers or fathers far away, like to Huntington or Charleston, into Recovery Point or the other drug rehabilitation centers. And so, you're without your children for so long. And so what I would see, which would be an unbelievable benefit, and obviously would never be able to be elected in the legislature because of some of my views, but I think that the way we need to approach it is to get the resources on the local level. And it's key, and it's the only way that we're going to really hit the program in the years to come, because if we can't keep these people back where they belong, there's just a total disconnect. I mean, if you send a mother away from her 5-month-old child for 9 months, the bonding, you lose so much. And so what I'd like to say is that we've got a long way to go, but I'll have to admit we have come so far since I first started being a public defender. Back when I first started, there really weren't even abuse and neglect petitions. Of course, there weren't cell phones or really computers either, but but you've come quite a ways in that far. But I think that if we can approach it head on, and if we can get the resources down to a local level, the mental health, that's one of the biggest problems that we have in rural Appalachia, and I'm sure throughout, well, I know it is, because there's hardly any place for juveniles that suffer mental illness. And that's also a very large problem for our adults. There are no mental health. The ones that we have, they try. I'm not saying, but without the funding, they're just not able to do the job that they need to do. Someone may argue with me, but I see it daily. We do all the mental hygiene hearings. And so I think that what we need to focus on in order to address good criminal justice in Appalachia is to try to get everything back to the local level. And I think if we can do that, we can succeed and can actually do some good like we're supposed to be doing. And of course, if anybody would like to be a public defender, I'd certainly like to talk to you at some point, because we need good ones. And anyone that's coming here on a Saturday afternoon that wants to be a public defender would be A in my book.
Richard Walker is a senior litigator with the Federal Public Defender's Office in the Northern District of West Virginia. He's had that position since 2003. Before that, he worked in Florida, private practice of criminal defense. Incidentally, he does trial work, appellate work. Maybe he moved here for the weather, I don't know, but Richard Walker.
Thank you, Jeff. I think we could do a 2-day seminar in 2 rooms with a lunch, a dinner, and a breakfast just on this,
Yes.
on this topic. It's hard for us to cover all of what we know or would like to know or like to discuss about these issues. And we're really focusing, seems today, on the addiction crisis in this state, which, by the way, also exists in every other state. And I will say that I agree with all of the comments that have been made, and join in the advocacy for more drug courts and treatment-focused approach within the criminal justice system. I work very closely before Judge Alloy, and I'm very familiar with his philosophies, his ideas, and the work that he does on a day-to-day basis, because I appear before him on almost a day-to-day basis. He's a fine judge, one of the finest. So I'm glad that you had the benefit of listening to his comments before we came in here today. I don't want to repeat what has already been stated as much as I can possibly avoid doing that. So what I will tell you is a little bit about what, as a criminal defense attorney, what we do on a regular basis to deal with this problem. I do agree, before I get into sort of my protocol as a practitioner, I will say that from what I did here today, what I agree with more than anything is that the issue is resources. That's what can make the difference. And unfortunately, I've learned after 20 years of law practice that the attorneys don't control the resources, and prosecutors don't control the resources. The judges, with the exception of judges in administrative position, the chief judge for a court or a district, don't control the resources. And this comes down to politicians, legislators, and other individuals in our government. It's just not something that we can control or direct or really influence. That's very, very frustrating to me, because if I could control the resources, if I could direct them, then I think I could have an impact. And that's what we all want to do. Okay, we all want to use our skills and our background and our education and our position within the legal system to have an impact, because we care. Everybody on this panel clearly is very dedicated to the community, to our clients, to the court, to the county. If you can control the resources, if we could do more in that regard, we could have more of an impact. So, given that we can't control the resources, we work within our system to do everything possible, creating drug courts and other programs, making the best decisions that are possible with regard to the appropriate sentence. I mean, we work with what we have. That brings me to my process. I want to tell you what I do. I work for the individual, many individuals, and what I do when I have a client, and most of my cases involve some kind of addiction problem. What I do, my first move is I find treatment for my clients. Sometimes we can do that within the court system, most of the time we have to go to independent treatment providers in the community and locate an available bed, make contact with the treatment provider, and make a connection between my client and the treatment program. So that's the first thing that we do in our office. And it's important. It doesn't matter what the direction of the case will be. It's important for our client to get into treatment right away. It's important so that the client can be released after a detention hearing. It's important if the client is released for the client to comply with the conditions of release. It's important because if a client is in treatment, I can have a better relationship and a more productive relationship with that person. So treatment is our first option. After we are able to explore and hopefully obtain a treatment option for our clients, the second thing that we try to do is we try to take the case outside of the criminal justice system. I don't want my client in the criminal justice system. I want my client out of the criminal justice system. So I immediately think and try to explore some type of diversion. We have diversionary programs in the federal system. There are diversionary programs in state systems around the country. I've tried to create, because before opiates there was meth. And I encountered dozens and dozens and dozens of clients who were addicted to methamphetamine. And I proposed a diversionary program for all of the low-level addicted defendants and people who were simply under investigation or known to the drug task force. I proposed a diversionary program that I think would have two benefits. One, it would capture and create an intervention for all of those individuals. It would give an opportunity for all of those individuals to get treatment that may be available and that they would certainly need. And also, the benefit was to avoid a criminal conviction. I mean, it's as simple as that. I don't want my clients convicted. I don't want people in the community convicted of felonies. That's one of it's a major portion of my mission, if it can be appropriately avoided. So we have diversionary programs. We try to create additional diversionary programs. The diversionary program that I proposed was never accepted by the U.S. Attorney's Office. I'm not going to give up on things like that, so I'll wait for a new audience and continue to try to pursue diversions, because I don't want my clients in the criminal justice system. Okay, so after we seek treatment and after we explore diversion, then I get to drug court, because I have a client who is going to remain in the justice system. I can't avoid the defendant's participation in the criminal justice process, so I seek placement in drug court, and that's done through an application. We have 2 drug courts right now in the Northern District of West Virginia. You've probably heard some things about them. It's, as everyone has said on this panel, as I'm sure Judge Alloy has indicated earlier today, it's a program that has a lot of promise. It's a program that it can be very successful. And if you want to know what Richard Walker thinks about drug court, I think we need 2 more tomorrow in the federal justice system. We need one in Elkins, and we need one in Martinsburg. We have 2, so we need to double it. And right now, we also need to, in my opinion, the drug courts, they should be larger. I think in the Wheeling Point of Holding Court, there are, on average, about 12 individuals in the drug court program. That's the drug court program in the federal system in this district that is the longest standing drug court. I think it's about 3 years old. I think it should double in size, if possible, if that can be done. Obviously, we go back to resources, which is complicated. Clarksburg probably has maybe close to 10 now, 8 to 10, and I have a couple of clients who are in that program. They need to grow, and we need those drug courts in other locations throughout the district. That's what the federal system can do to improve the approach, to do more. But that's really my third option as a criminal defense attorney. And we've been successful, not always. Not all of my clients are appropriate for drug court, but we try. We try where we have a case that seems to be a good fit. Most of my clients have addiction problems. Many of my clients are nonviolent. And most of my clients, if they are involved in some kind of crime, there's a connection between their addiction problem and the offense that's at issue. So that's the third option. Beyond drug court, when it comes to addiction, clients who are addicted, who have a documented history of addiction, what I do is I start to negotiate. And I try to demonstrate to the prosecutors handling the case that the case is, in essence, about addiction. And I try to use that background so that I can influence the outcome of the case, so that I can find some kind of resolution that would be favorable to my client. Again, what I always want to do is avoid a felony conviction, if I possibly can. If a felony conviction must be involved in a particular case, then what I try to do is negotiate for the least serious felony offense. And sometimes I can make an effective argument based on the addiction problem that's evident in the case, that the least serious charge is appropriate, or some other less serious charge would be appropriate. So that's the fourth thing that we do. Then we go to trial. But if a case doesn't go to, and I don't want to talk about trials today because this isn't a trial advocacy program. But we go to trial. If we're not going to trial, then when it comes to addiction, and when it comes to the problems that many of my clients face with regard to opiates and other drugs that are involved, we make presentations at sentencing hearings, and we call that mitigation. So we investigate, we learn about our client's background, we talk to the treatment provider. Remember, the first thing we do is get the client into treatment. We talk to the treatment provider to see how well the client has been doing in treatment. We bring in experts to evaluate our clients, not only for their status with regard to recovery, but also mental health problems and other issues that may be relevant at sentencing. And we make a presentation at sentencing for a reduced sentence. Most of the time, in almost every case, drugs, addiction is part of that presentation. So that's an idea of what we do on a day-to-day basis from a practitioner's point of view to help individuals. I wish I could help hundreds and thousands of people. I can't. I can help tens, tens of 10 people a year, 20 people a year. I have about 100 cases a year. So again, I work within the confines of my position. I work within the confines of the mission of my office. I work within the confines of the appointment order that I have, and those are the ways, those are the steps that we go through to help people. We're going in the right direction. There have been a lot of changes in 20 years, and it's encouraging. There's much more that must be done. Thank you.
Thank you. Thank you. You can see why I wanted two experienced public defenders on the panel. You have a gold mine of experience here. I can tell you, just reacting to one of the things that Richard said, the power of a defense attorney coming to me, the prosecutor, with a treatment plan, either already the plan is in existence, or maybe you've started to already implement the plan. Notice he didn't say, I asked for permission. I waited for the court order. I was waiting to see if somebody would approve it. He didn't say that. He said it's the first thing he does. Now, if I'm sitting in the courtroom and he comes to me on the first pretrial and starts for the first time talking about, well, what if, how about treatment for my guy? I'm thinking, how long have we been at this? We're at the first pretrial and you're just starting to talk about this? But if he comes into me and says, hey, my guy's in treatment, even if I'm not in the mood, or I thought I wasn't, even if I'm not thinking that this is the direction that case is going to go, I'm at the very least going to listen and hear him out. And I'm all about personal responsibility. I preach it all the time. You know, take this into your own hands and do things. And if he's done that and his client's done that, that's going to be an effective tool for you to use for your clients. Go ahead.
Just follow up on that
Thank you.
observation. And I think from a defense perspective, it's crucial that you're proactive. The last thing I want to hear at a sentencing hearing is my client's asking for probation, and if you order him to go to drug treatment, he'll go.
Yeah.
because I'm sitting there at the back end of this situation, maybe a year out. Because you've had an arrest, if it's a felony arrest, you've had a preliminary hearing, you've had a grand jury and indictment, you've had an arraignment, you've had a plea hearing, and even 60 days after the plea hearing. I mean, even if you haven't done anything up to the plea, between plea and sentencing is at the latest time to get proactive. Don't get proactive at a sentencing hearing. And all of a sudden realize, oh my gosh, I've got a drug problem. And then expect me to be sympathetic to, or to be inclined to order somebody to do something. I mean, from my perspective, in fact, and everybody's been involved in drug court is a voluntary program. We don't order people to go to drug court. Now, I have ordered people to apply, but you will not get into a drug court program if you are not there on a voluntary basis, because you're told that. And if you go to an assessment interview for a drug court, and tell your clients this, if you go to the assessment interview and tell the person that's assessing you that you don't have a drug problem, guess what? You have just excluded yourself from drug court. Because you don't take people that don't have drug problems. We only take high-risk, high-need people. So it's a proactive thing. And of course, the problem with this, I'm sure Richard can tell you, this is the last thing your addict clients want to do is admit to you that they're an addict. And that they got a problem, and that they need help. So sometimes that's the first step.
Judge Keller and Stanton, I wonder if you'd talk to us about what's the difference between diversion and drug court?
Well, in our county, it's called the Adult Diversion Program. So actually, in our county, drug court is the diversion program. Is it the same in Huntington?
Drug court is a diversion program. Of course, there are other things that people could do. I mean, they may go on just home confinement, regular probation, community corrections. Drug court is a highly supervised, structured diversion program. So I think, as Judge Clawges mentioned, you know, we look for people that are high risk and high need for drug court. If you could do a diversion otherwise, then you don't need to be in drug court.
Right.
You know, and we have a lot of people that relapse in drug court, and that's not unexpected, especially early on in the program. And if they don't ever have a relapse while they're in drug court, they probably didn't need to be there. They probably could have done regular probation or a home confinement program or something else. So it isn't a type of diversion.
Right, right.
And we have the Day Report Center, and what we use, and some other counties may be doing it differently, but a lot of the times, and of course, like I said, you know, most of my clients all know me on a first name basis, and they don't try to tell me they're not an addict because I live in Mayberry. So what we try to do first to kind of we want the people to succeed, and a lot of times what we'll do first is we have a Day Report Center, and then we'll put them as a condition of their bond. Used to, if you had a drug charge in our county, the magistrates typically and the circuit judge would usually uphold a high bond, say $50,000 even, for example, for a delivery, especially if they knew that they were one of the bigger drug dealers in the county. So what we've been doing recently is we've been putting their bond on a PR bond, which to me was unheard of for a felony charge, with the added stipulation that they be on home confinement and participate in the Day Report program every day. And so we do that usually right at the preliminary hearing stage, so we have an idea by the time that we get to the plea for drug court whether that they're going to make the effort needed. There are several people that can't even make it through that first initial stage, but we've used that very successfully to see you know, if they can participate in the program. So we do that a lot, and the Day Report Centers work very well and have a lot of evidence-based programs which can help if they're not someone that we really feel would be an appropriate candidate for a drug court term.
Yeah, and it's, of course, drug court programs are not available to drug dealers. Although I've learned over the years that there are drug dealers and there are drug dealers.
Right.
And there are people who sell drugs to support their habit. They're not drug dealers. The drug dealers, and actually there are two ways that I've discovered how you can tell drug dealers from drug dealers. One is they're in the federal system because it used to be the feds took all the drug dealers.
Yeah.
And so if I had them, I knew they weren't the real drug dealers. They were just the people who were sporting their habit. The other tip-off nowadays, since there seems to be more of an even split, is if their home address is Detroit. That's usually a pretty good indication.
I grew up in
they fit
Detroit.
The latter category.
Just so you know.
Drug dealer.
Yeah, go ahead, John.
That's it.
Except-
Yeah. True statement. I'm an assistant prosecuting attorney in a little southern Ohio county, Lawrence County, directly across the river from Cabell County, Huntington, where we live. I say we're a part-time. All of us in the office are part-time. We laugh about that because we're paid part-time, but we work for full-time. We're right on the pipeline. The highway that goes through our county is right on the pipeline from Detroit, Columbus, Huntington. So we have a lot of exactly what you were talking about, Your Honor. The difference between somebody who is primarily using and selling some on the side to facilitate purchase of more drugs for themselves to use, different from the person with lots of whatever it is, heroin or whatever, in the taillight of their rented car that's pulled over on the side of the road.
Or as the one guy I had from Detroit, he had a used car lot on the side. And in fact, he asked permission to leave the state to go back to handle some dealings with his used car lot, which permission was unwisely given. Well, maybe it was wisely given because as he was on his way back from his used car lot, he was pulled over in Ohio with a whole bunch of drugs on a secret compartment in the trunk of his car. So you get that. Of course, Morgantown is interesting because, you know, Detroit used to be the source for Cabell County long before it was the source for Morgantown. In Morgantown, it used to be people drove to Pittsburgh and got their drugs. Or they came from east, from Martinsburg, unfortunately for those from the Eastern Panhandle and Philadelphia and those areas. Now it seems that the Detroit folks have taken over.
Our office actually operates a small diversion program. Ohio permits prosecutors' offices to actually operate their own diversion program. They, by statute, they carve out from that, though, drug offenses. Why would they carve out drug offenses when they're trying to enable the prosecutor to have a diversion program? And the only thing I can figure out is they're trying to make sure that prosecutors don't start diversion programs in their office that are going to then compete with or conflict with a sanctioned drug court through the Supreme Court. And our county is, of course, is now finally up and running with a drug court. What we use for diversion is typically low-level offenses, sometimes even some low-level felonies for various reasons, but it doesn't have the accountability factor and the treatment team factor. There's a treatment team, but it's sort of operates in the background. And it doesn't have the enforcement capability that the court-operated drug court has.
And we meet, I mean, it's very intense, not only is it intense for the participants, it's extremely intense for the treatment team. Because I never dreamed how emotionally involved you could get in a drug court team meeting, as opposed to it's the same people that we're dealing with that have been doing drugs for years, and then you get them in the program, and then all of a sudden you're worried about everything else in their life, and it's been a complete, you need to wrap your head around it in a completely different way, because I mean, at least in our county, and I assume it's pretty much the same everywhere, they meet every week. The treatment team meets every week for an hour or two, whatever it takes to go through every single individual, every day, you know, every week, and what they've done right, what they've done wrong, what we think we could do, what additional services we could offer them. I mean, it's intense, and it gets, I mean, I argue with the prosecutors, who are my best friends, after the argument, but, you know, during the, I mean, it gets very loud. There are, especially the law enforcement, of course, you know, I'm a public defender, but there's a bailiff that's also a long-term deputy. I mean, you know, they just shake their heads. The first time that they screw up, and as Judge Kelly said, they're gonna screw up they're always gonna, I mean, I've never had one yet that hasn't screwed up at least once. And so, I mean, they're like, get them out of here, you know, they're not gonna work. So you have to change their whole way of thinking to be an effective treatment team, I think. And like I said, I've been doing it a lot longer than anyone else sitting here, but that's the biggest change with me is just that it's, you're involved in every facet of their life. You knew things, you may have represented them for 25 years, but you didn't know that they were raped when they were 10 because in the scheme of their other crimes, that was not important or relevant at that point in time to, you know, whether they stole something at, you know, Walmart. So that's one thing that I see. I mean, the people on the treatment team have to be committed, and they have to be able to be pretty open-minded, because you put a closed-minded person on there and it's just not fun to deal with them.
Of your caseload, how many of your cases typically do you find to be drug-related? Now, whether it's directly drugs or drug offenses or other offenses that are motivated by the desire to get drugs?
Well, I have, my personal caseload's over 300 a year, and I would say 90% of them are drug-related, no question. Now, it may be forgery and uttering.
Yep.
You know, they may be, you know, writing bad checks, stealing the checkbook from their parents, writing the check so they can buy drugs.
Right.
It could be shoplifting so they can get something to sell to the pawn shop, but I would be very certain to say 90% of my cases.
That's about where we are. Richard, you about the same?
Maybe 85.
Yeah.
Just because we have, you know, some tax cases and different types of financial fraud, and we get a lot of prison cases too, and that's not typically drug related. Can be, but not typically. So 80, 75, 80 have some drug connection. That's a high percentage. But when I was a public defender in state court, it was every case. It was I was in a major metro, every case. That was more of a crack cocaine problem 20 years ago.
Yeah.
But every case.
Yes, ma'am.
I have a question. I spoke with a nurse about a month ago, and she was an RN in home health and in Boone County, and she took drugs from a client in a home. And that person passed away, but the family pursued charges. She was charged with a felony and also was put on an exclusion list where she couldn't work in any facility that had Medicaid or Medicare funding. She's been in a monitoring program with West Virginia Restore for RNs for over 2 years. She has a probation officer who told her that there was she was poor use of his services at this time. And he suggested that she wait another year and then try to go back to court and get that felony dropped. Now, would she be applicable to that second chances?
Yeah. This West Virginia?
Yes.
What's the waiting period for the second chance?
10 years.
Yeah, it's 10
10
years.
years.
10 years
10 years.
post
10 years.
Can you imagine waiting 10 years to be able to get a job again?
That was
Beyond
ridiculous.
McDonald's.
I mean, honestly, that's just
Yeah.
ridiculous. When they did pass that legislation, put 10 years, I mean, it's not helping anyone.
It's kind of a backhanded effort.
And she has her nursing license back. She could work. She's been working in non-nursing positions. She could work.
As a nurse, but why not?
No company,
Nobody will hire her.
as soon as they hear that felony, they're like, hey,
I'm not sure what her underlying felony was.
where she stole the
Stole the
drugs.
drugs.
They called it.
Drugs.
Yeah, she was charged with a felony.
Sometimes we charge people
And-
too high.
Yeah,
I
well,
was gonna say, we
I
would
think
pat him on the back. then.
that's
Yeah.
the, and I think, Richard hit on it, and that is the best way of dealing with this. And the best way of protecting your client from a felony conviction is to address it head on from the beginning and to take steps to try to get into a diversion program. I know Our prosecutor is using diversions, and not necessarily for drug court, for other areas, but it's a diversion program that involves a felony plea, acceptance of which is deferred pending a 1 or 2 year diversion program that's supervised. If they successfully complete the diversion program, then they're allowed to withdraw the felony plea and enter a plea to a misdemeanor, or in a very limited number of cases, walk away without any criminal record at all. But I think that's where right case, a defense attorney that takes the lead on that up front and works on it can do the greatest benefit for your client, because the best way to deal with a felony conviction is not to have one. Because once you've got it, it is extremely difficult to either get it expunged. Well, you can't get it expunged in West Virginia. You've got the second chance program. The second chance program doesn't even expunge your record. It changes, and I'm still not sure how effective this is going to be in the long run, that felony conviction from a record standpoint, from a felony to a misdemeanor. However, a diligent employer who does any kind of a background check is still going to find that felony conviction.
And we had one like that, and what happens is when when you do a diversion like that, their felonies entered into NCIC and through the state troopers have the database. But then the people that are actually entering the information into the system don't understand what they're supposed to do with that felony once it's gone. So I had a client that was out in Colorado and tried to get a job with Uber, and who was not supposed to have anything. And I'd done a cursory check, but then they call up, they're like, we're still showing a felony. And it was a records keeping thing, but of course at that point, it was too late. And they had this other, the legislation's, the Bill Laird Second Chances Act for, to get your driver's license back. That's kind of a joke as well. I knew I'd probably say it. But anyway, because what they do is, it sounds great in theory, and Sheriff Laird out of Fayette County was extremely dedicated. And a big problem with these drug users is they can't drive, and they've lost their license, and they can't afford to pay their fines. And so they came up with this idea: if you apply for this program and you're accepted, you'll get your driver's license back eventually if you pay so much a month. But I've had at least probably 100 of my clients apply for that. 2 have been accepted, and that was months ago, and neither of them have their privileges back. So it sounds, if you're down in Charleston, you're listening to the bill being presented, it sounds like it's going to be great, but in reality, it's not there yet.
What you're talking about, if I understand correctly, is because when they passed the law, they didn't give the DMV people to handle the applications, and as a result, there's a tremendous backlog administratively and even handling the applications.
Ohio's expungement statute provides you're eligible 3 years after the exhaustion of all appeals, and you're off paper. So 3 years after everything's done. But it's only if it's like a first offense, and then there's a list of some offenses that are not expungible.
Jeff, do you know whether they've had any studies in Ohio? What's your recidivism rate among those whose records have been expunged?
I do not know, Judge. I don't know that. It's not responsive to your question. They've tried a sort of a middle ground. They created something called a Certificate of Achievement and Employability. Sounds good. It's for an offender who's out of prison, out of confinement, but before that 3-year period has ticked by, they can obtain this from the Department of Rehabilitation, and they have to do certain things in prison to qualify for this. They've got to complete a vocational program, they've got to do other stuff. And once they do that, that's given to them in an effort to try to close the gap a little bit on behalf of some of these folks who are out of confinement but not yet eligible for expungement, and who frankly might not ever be eligible for expungement because it was the 4th felony that they had. But yet they're still, go ahead, sir.
Oh, I think this question is specific for Mr. Walker. Earlier we had a session discussing about the impact of the session memos, with U.S. attorneys having been charged the highest ground possible. How much has that influenced your work when it comes to drug-related cases? More specifically, an individual would have like a different charge normally being negotiated out for this lower, from what you discussed about.
It makes it more difficult. It's changing things. The directives from Washington, D.C., I mean, that's what's different about working in the federal system, because in a particular county, you know, the prosecuting attorney is the boss, makes the policy. No one supervises the prosecuting attorney in a particular county, so that prosecutor can set policy. But in the federal system, what happens in Washington, D.C. makes a difference. And one memo, like the Sessions memo, can affect the status and the progression in the future of hundreds and thousands of cases across the country over time. So the Sessions memo has had an impact. I've seen memos like that before. You do the best you can. We're trying more cases now. That's what's happening, because we can't settle the case in a way that's favorable to our clients in many cases. It makes it more difficult, so we try more cases, and that's happened. I mean, 15 years ago when I first came to this district, I tried a lot of cases because we had I guess you could call it a strict approach towards criminal cases in the federal system. We had mandatory guidelines, we had many minimum mandatory penalties, so we tried a lot of cases. But then when many changes occurred, we didn't try as many cases because we could settle cases and resolve and negotiate them. Then now we have drug courts. I mean, there are more options now. But the Sessions memo, essentially, we're going back 20, 25. I think I might even have sarcastically said it in court, and I'm sorry, you know, this is not 1985, but it's turning out to be like 1980 or 1985 all over again in terms of the criminal justice system. So we progressed 30, 35, 40 years, but now there's a regression, in my opinion. Some people may agree with that. I don't agree with that, and most prosecutors and most judges don't want to see the system go backwards, don't want to see it backslide. It doesn't mean we open up the prisons, it doesn't mean people don't get prosecuted and convicted and punished, but there's more of a sensible approach that's existed over the last 20 years. But the Sessions memo is an example of a change, in my opinion, for the worse. We're going back in time. Yes.
Yes, sir.
I'm an employment lawyer with Legal Services in West Virginia, and have been involved in addressing opioid addiction as a disability, which is classifiable as drug addiction is a disability under our state human rights, and probably Ohio has an analogous state human rights and our Federal Americans with Disabilities Act. And that may mean certain things for due process in the criminal process and in the process of detention as far as access to treatment and so on. But I want to ask you a question about the availability of accommodations for accessing the workplace in the probation process, because it came up on a panel that I hosted here yesterday. Our clinical psychologist from the Logan County Day Report Center said she encounters folks in probation who don't get referred to her Day Report Center because the probation officer is concerned that a referral for drug treatment will jeopardize that probation, the person's job prospects in completing their course of probation. And I wonder if any of you could comment about the role that accessing stable employment plays in your process of moving people through probation and getting them into treatment. Do you see that employment is either a barrier to getting people into treatment, or the lack of employment? Is that a barrier to getting people into treatment? I'm searching for ways to think about how we who engage in the workplace can support a successful rehabilitation process for people in the criminal justice system. I don't know if that's a helpful question, but an answer would certainly be helpful to me in finding ways to support you.
Employment is so key to long-term success for recovery, because you've got to be able to support yourself without turning to criminal activities. One of the things that we focus on a lot in our drug court is to try to help people with their employment. And we have tried to make it a selling point to employers that they're in drug court. Because if you're in drug court, you are being supervised and you are being monitored very intensely.
Tested.
And if you have a problem as an employer, we tell them, it's like, you call the probation officer. We'll come out there, we'll talk to them, we've got our finger on them. And so we try to really sell this as a real plus for employment, and we've been very successful that way.
just this last week at our drug court treatment team meeting, we had a group from Webster County called J.C. Hammer Lumber Company, and they actually came to us, and they're one of the few companies that we've been able to find that would employ someone in our the children, kids in our situation or adults, and they're really going to come and hire these people because they feel more assured because we're randomly drug testing them. Their problem is the people that they've had that have been there for years are now failing drug tests. So they actually came to us, said at our meeting, and as long as we try to, our first goal in order to get them employed, sir, is to try to get their license back, because that's really, in my area, you know, it's a rural area with lots of geographical locations where they could even get employed. So what we do at our day, the people in the drug court programs at the day report center every day, we really try to focus on trying to get their license back, because it's almost impossible in a rural area to get a job because you can't walk because there's not big downtowns.
Right.
So once we can get, we try to start in their first phase of their treatment program, is we try to concentrate it, and probably 80% of them don't have license. They've lost it for some reason. So we get them into little side jobs where that they could work and start, you know, paying their fees, because we haven't had any luck with the second chances.
And give them IDs.
And get them IDs so that
They
we
don't
can
have
get
an ID for a job.
So that's where we start, but I was just very, I mean, I couldn't believe that someone came to us and wanted to hire several of our clients, and it was just, it was a very good day. I couldn't believe it, actually.
Yeah, and actually, the specific issue that you raised appears to be a communication issue between day report and probation. And I think they should be on the same page with regard to that. I'm not sure what the problem is. And it is interesting, though. I mean, our people that go into the second phase of drug court do not seem to have trouble finding jobs, which is interesting. I mean, but of course, this is Montague County, and with the lowest unemployment rate in the state, and we've probably got more fast food jobs here than anywhere else. And a lot of these people do end up in fast food and in your lower wage jobs, although we've got at least a couple, 3 people that are working in construction. And although, well, one of the employers is a recovering addict. Actually, was highlighted on WDTV5 a couple of weeks ago, and so he's making it a practice of hiring recovering addicts to work for him. But it's, you know, I mean, it's kind of crazy. I mean, you know, our goal is recovery. Is to get people in active recovery who are actually working their programs, and actually with people in drug court. I'm sure Pat sees this all the time. That's you're waiting for that light bulb to go off. It goes off from between I'm staying out of jail, I'm staying out of jail, I'm staying out of jail, to I'm in recovery, I'm in recovery. And it's you're waiting for that to happen, and some people go through the whole program and it never happens, and you realize that even though they may graduate, they're probably going to relapse. And we probably see more relapse post-graduation than we do recidivism post-graduation, but we also see people who then go back into recovery.
Because they know they can do it.
Yeah.
And that's the big piece to it. They know that they have the potential and they have the ability to get back into recovery, and the change is dramatic. It sounds so cliche, but they're really entirely different people after about a year or so. So it works. It's remarkable, and it's very inspiring. Man.
We have them take pictures when they,
Oh, yeah.
we take their mug shots, and then we always give them, and of course, we don't have any graduates yet because our program's new, but we're real close. But it's amazing, just in a short amount of time, we show them their picture, and I mean, it's inspiring to them, because I mean, honestly, people that will come in from my office, my secretaries, and they won't recognize the same person that's been in my office for 20 years. It's that different.
Yeah, and you know, I mean, an addiction, I think it was pointed out earlier, I mean, a 28-day program is not the solution for addiction. Detox is not the solution. The 28-day program is not, I mean, the solution for addiction is recovery, and recovery is a lifelong experience. And it's not just 6 months, it's not 90 days, it's life. And it's a matter of, well, it's 2 parts. It's educating people and keeping them clean long enough that their brain can heal. Because the amazing thing about addiction is and the studies all showed, is that the use of these kind of cocaine, opiates, methamphetamines, all these drugs affect physical changes in the brain. And as long as you're using drugs, those changes don't only get worse, they don't get better. If you stop using drugs, the good news is if you stop using drugs, the brain does have the ability to heal, but it takes time. And it's not just weeks, it's months, it's years, it's actually probably a year or longer before you start seeing real change. And it's keeping people clean long enough for at least the changes to occur in their brain, and also for you to make the changes in their lifestyle and in their attitude, and giving them a reason for living. You know, I mean, I grew up in Morgantown. I grew up in Westover on the wrong side of the river, but I mean, I grew up in what I believe to be a normal household. Most of the people that I see don't come from normal households. What their understanding of what's expected of them is completely different from what I grew up with. And that's probably one of the things that took me the longest to figure out, is that the things that make perfect sense to me don't make any sense to them because they're clueless. And it's getting them to understand what it is to be normal, what we consider to be normal. And you're all sitting here, you all come from normal families, normal backgrounds, you're upper middle class, and you don't know where these people come from, and to a large degree, I still don't know where most of these people come from, and I still don't understand it. But, as Judge Alley said, understanding that's part of fixing the problem, and that's hard, especially, that's not the background of judges. That's not what judges are trained to do. At least Pat had the ability, had a social work background. Yeah. They don't teach math majors that kind of stuff.
All day yesterday and today, we've really been listening to multi-person presentations, panel presentations by people from various backgrounds. We've talked about that, haven't we, about the multidisciplinary approach to this problem. Have we thought about any other ways in which the fact that we have started to implement a multidisciplinary approach to this problem in the criminal justice system, are there other areas that might be amenable to a similar approach? I'm thinking of the intersection of criminal justice and mental health, or other areas in which a collaborative approach might be worth exploring.
I mean, we've touched on family law and abuse and neglect, and I think that's probably the next big area that needs to be addressed. And right now, there doesn't seem to be any interest. I think there's interest at our level.
Yeah, they're interested at
A
our
lot of
level.
interest at our level, but there's no interest at the administrative level from the court's standpoint to expanding the concept of drug court to the family courts or to the abuse and neglect process. And I think that is the next step. Of course, the mental health, we've had some forays into mental health courts in West Virginia. That's kind of hit a brick wall, and there doesn't seem to be any real interest in expanding their veterans courts. There doesn't seem to be any interest in expanding there, at least not in name. You'll probably find that most drug courts let's face it, most people that have substance problems also have co-occurring mental health problems, so you can't deal with one without dealing with the other. So we're doing it. If you have somebody in your drug court that's a veteran, you're also dealing with the veterans issues too, and trying to hook them up with the resources that are available there. So I mean, we may not be doing it in name, we may not be doing it officially, but it's being done to the extent that we can.
And we've lost a few because we can't address the mental health issues in drug court.
It's
I mean,
really
that's
difficult.
a real problem. We had, he just had such a long history, well, two of them have had such a long history of mental illness, and we really don't have the resources to address that and the drug problem, and it is a failure at this point in time in that regard, I think.
Well, mental health in West Virginia is a systemic problem that goes back to the 80s when they decided that we were putting too many people that were mentally ill in institutions, so we turned them all loose with community support, which was fine and dandy until the community support dried up. And now basically we have a mental health system that's a revolving door. People go off the wagon, if you will. They get picked up on a mental hygiene. They're committed for 10 days. They get their meds regulated. They're sent back out into the community. They're not committed for any long period of time. Occasionally somebody is, but for the most part, their meds are regulated. They're sent back out into the community with an appointment 90 days from now, if you're lucky, in a local mental health facility, which never happens because they're feeling better and they don't go back. And so they're okay for 6 months, a year, whatever it is. It's just back into the system. That's just a whole different problem. And we only see it when it spills over into.
Well, we react.
addiction.
We react. The cases that come to us are really, oftentimes you can tie them to a failure of another system. And I feel so strongly for the teachers that are picketing around the state, because that's where it starts. I mean, it's the educational systems and the mental health systems and the public health systems and the medical. I mean, you don't get a criminal case from nothing. When you get a criminal case because someone's been abused, you get a criminal case because someone has a mentally ill family member and they weren't educated, or they don't have access to service. And I was in Florida just when the shooting occurred in Broward County. That person didn't have the support that he needed. It's a terrible crime. It's the worst of all crimes. But he didn't have the support that he needed from the different systems in the community. He was very much at risk. So we get, there Richard Walker gets the case.
Yeah.
Wonderful.
Right.
How can I can't fix that. We can't fix that. We get it after it's very, very damaged and very, very problematic and very, very complex. And the older the defendant, the more difficult it is to have a positive impact on the defendant. So just, if there's one thing that I think really is a takeaway about the criminal justice system, is that, it's very visible what happens in the criminal justice system. And there are high profile events that happen in the justice system, but there's so much happening before a case gets to the criminal justice system that is important, and where resources are required and attention. There's a lot of attention that's needed. So that's what's never told. That's the story that's never told about the criminal justice system.
Yeah, it is so structured to be reactive,
right,
and not proactive.
And that's frustrating to us.
Yeah. All right, we're running short of time. I want to touch upon just a few other things, and then we're going to close. We'd be remiss if we didn't mention some other things. This is not all we do, is it? I mean, we've got a huge problem on our hands, but we've got other problems too, and we risk sort of forgetting, giving them some proper recognition. We've got a big domestic violence problem, don't we? That's a huge thing in Appalachia. It's not new either. Sexual assault, still got a big, huge problem with that. There is an initiative now, I'm sure you are aware of the efforts to test, or to process about up to 2,800 untested or unprocessed rape kits in our state. They've done, I'm told, about 700 of them, and so they're in the process of processing those. And that's not a panacea either. Don't we recognize that there are some issues that have to be looked at there? Now, what does your law school offer that no other law school in the country does? An LLM in forensic justice, right? There's going to be some work to do in this area in the coming years, and well, it's really honest with the testing that they're trying to reduce the backlog of these untested rape kits. Human trafficking. I have never had a human trafficking case in my career, and I've done this for 30 years. Don't tell me it's not, because it's not happening. I know it's happening. We're not getting these cases. We're not finding these things out. They're starting to train truck drivers, of all folks, to look, aren't they? To spot for, to look in when they're on the road and in rest areas for any indicators of human trafficking. Problems with an aging population. That's something that impacts the administration of criminal justice in our state. Cybercrime, of course, the mental illness. I agree. You may remember 1996, the fireworks disaster in Scotttown, Ohio, where someone went into a fireworks whatever store and threw a lit cigarette into a display case and 9 people were killed. That was my case. Wouldn't it have been nice if that guy had had some mental health intervention on the front end? Now he had brain injury, he had some executive function loss because of a brain injury, so he had some problems that he was just never going to overcome. But wouldn't it have been nice for that person to have been under some kind of mental health supervision, not punitive? Instead, there were 9 funerals. What can you do? You're sitting here, you're a law student. Your second year, your third year, you're thinking, God, I just got to get past the bar exam. Well, yeah, you got to get past the bar exam. But what can you do? The problem is so overwhelming. And you can start to feel like, well, there's just how can we ever make a dent in this? Here's how you do it. You're going to transition from law school to law practice. You're going to get a job. This is going to be a stressful time. You're going to go to big law, or you're going to go home and open up your own, or you're going to do something else in between, or you're going to go with one of the public defender's office, or the U.S. attorney, or a prosecutor's office. You're going to learn that you're not going to just be dealing with legal problems. You're going to be dealing with people who have legal issues, right? Big distinction to me. You're going to be assessing their legal issues, and as you can tell, the human issues that might be beneath the surface, but probably aren't too far beneath the surface. Learn something about your clients that doesn't have anything to do with the case. Burnout is an issue. I try to learn something about my clients. I have a civil practice on the side too, so I do civil work, and I try to learn something about my clients that doesn't have anything to do with their problem, because they are not their problem. And it might help you in your dealing with your burnout or whatever, burnout, just leave it there. Gaining experience is important. If you're going to do this work, whether you're a prosecutor or a public defender or a private attorney doing defense work, you need to learn how to try cases. You need to be comfortable in the courtroom. Get comfortable. I don't know of any lawyer that I work with, any prosecutor, who would turn down a new lawyer's request. Hey, would you help me? Would you look over this and see if I'm getting this defense just right? Can I go to court with you? Can I come and watch your trial? Heck, you don't need permission. You just go watch trials. Figure out somebody in your community who's good. And if you don't work for them or with them, watch them and see how they do it. Try cases. You got to pick your battles, right? We're not saying try everything. You can't do that. That's not going to be in your client's best interest or the state's best interest if you work as a prosecutor. Pick your battles, but try more cases. Bench trials are great. Start with bench trials. Start with speeding tickets. It's fine. Start with small claims. And then try some jury trials. You've got to be proficient to be taken seriously, right? If your opposition knows that you never go to trial, you think I don't know who goes to trial in my county? I know. I know who's never going to go, and I know who will take me on every time. Find a mentor. The Bar Association, CLE, there's all kinds of opportunities to do that. Another word about trials. You'll hear people say occasionally, oh, I have been doing this for X number of years, and I have done X number of trials, and I've never lost a case. Anybody ever hear that or read somebody? Here's my answer. They're not trying enough cases. Right?
They might not be telling the truth.
Probably what he said more than the first. Right. I've tried lots of jury trials, probably well over 100 jury trials, probably 150. I don't know. I don't keep score. I don't keep track. Because you know what? I'm still learning. I learn every time. I learn what not to do. I learn what blows up. I lose trials that I know I'm going to win, and I'll win some that I know there's no way in the world I can win this. You can't predict what a jury's going to do. I promise you that. So quit making predictions. Don't even start. And I'm getting my timeout signal here. But okay, one last thing. We've heard a lot about privilege. We've heard a lot about great messages. We've heard a lot of great speakers. Here's one last thing I want to leave with you, and it is the idea of privilege. And it's the privilege that I think that we need to highlight. And it's the privilege that I try to stay mindful of. And it's the privilege of being a lawyer. It's the privilege of serving somebody, or your county, or your government, or whatever, or the victim of the crime that you're dealing with. It's a privilege to work in this profession. You're about to embark on a career. I urge you and I challenge you to be mindful of the privilege. People want fairness. They want justice. Professor Pruitt said there's no way we would be able to tease ourselves and say we always get it right. No one would have the audacity to say, well, that we always do justice, but we always try to do justice. And it's imperative that we continue to try to do justice. That's what Appalachia calls for. That's what our people need. Who will answer the call? Thank you very much.
See how that story's been going. You don't get a hearing.